Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court has agreed to hear a petition which sought to know whether the specification of life sentence would mean the entire life or can it be commuted or remitted by the powers under Section 432 of the Code of Criminal Procedure. Section 432 CRPC deals with powers to suspend or remit sentences. A bench of Justice Harishikesh Roy and Justice Prashant Kumar Mishra issued notice to the Delhi government seeking its response on the petition filed by Chandrakant Jha, who is serving life term after being convicted in 3 murder cases in which headless torsos were found outside the F.I.R jail here in 2006 and 2007. In his petition, Jha said that he has been convicted for offences under Section 302 murder and Section 201 causing disappearance of evidence of offence of the Indian Penal Code. He said that the Delhi High Court had earlier commuted the death sentence awarded to him by a trial court and converted it to life imprisonment, but with a rider, the sentence of the life imprisonment would mean full term of the life of the petitioner. Bail in terror cases must be rejected as a rule when courts have reasonable grounds to believe that the charges are prima facie true. The Supreme Court has held in a judgment that prescribes a twin-pronged test, severely narrowing the scope of the Bail in Unlawful Activities Prevention Act UAPA. According to a bench of Justice M. Sundaresh and Justice Aravind Kumar, the conventional idea in bail jurisprudence that the discretion of courts must tilt in favor of the often quoted phrase, bail is the rule, jail is the exception, does not find any place while dealing with the bail application under UAPA. In such instances, the bench noted courts are merely examining if there is justification to reject bail. It further underscored that the test of rejection of bail is quite plain under UAPA. It is only if the test for rejection of bail is not satisfied, the bench held, the courts would proceed to decide the bail application in accordance with the tripod test or triple test, whether the accused is a flight risk, can influence witness, or tamper with the evidence. The Supreme Court has agreed to hear a petition against a High Court order that quashed a law providing for 75% reservation in private sector jobs in Haryana. Appearing for the Haryana government, Solicitor General Tushar Mehta argued that the Punjab and Haryana High Court's ruling was rendered without adequate reasoning. A bench of Justice P.S. Narasimha and Justice Aravind Kumar issued a notice to the Union Government and the Faridabad Industries Association. The Apex Court has said that the case would be listed for a final hearing very soon. Last November, the High Court set aside the Haryana State Employment of Local Candidates Act 2020, saying that the provision pertaining to 75% reservation in private sector jobs was unconstitutional. The Act covered those jobs that offer a maximum monthly salary or wages of up to Rs 30,000. The law would have been made applicable to locals who have a domicile or a residency certificate for Haryana. The Supreme Court has said that the state governments cannot be selective in granting reservation benefits to backward classes as it will lead to a dangerous trend of appeasement, but subcategorization can be tailored out by laying down criteria. Examining whether states can subclassify the scheduled caste and scheduled tribes for the grant of a quota within a quota, a 7-judge bench led by CJ Diva Chandrachud said that the state cannot exclude others while conferring reservation benefits on most of the backward classes. The court reserved its judgment after hearing the submissions of the center states others on references to revisit a 2004 judgment of a 5-judge constitution bench in the case of E.V. Chennaiya versus the state of Andhra Pradesh, in which it was held that the SCs and STs are homogeneous groups and hence states cannot further subclassify them to grant a quota within a quota for more deprived and weaker caste in these groups. Now let's have an overview of high courts. The single judge bench of the Jharkhand High Court has held that if multiple F.I.Rs by the same person against the same accused are permitted to be registered in respect of the same set of facts and allegations, it will result in the accused getting entangled in multiple criminal proceedings for the same alleged offence. The court observed that the accused may become involved in several criminal proceedings for the same alleged offences if several F.I.Rs filed by the same person against the same accused are allowed to be recorded considering the same facts and allegations. Hence, the registration of such multiple F.I.Rs is nothing but an abuse of the process of law. The Tripura High Court has held that when in any establishment the provisions of the Payment of Gratuity Act 1972 are applicable automatically, the calculation shall have to be made as per the limits as are prescribed by the central government from time to time. The court observed that Section 14 of the Act overrides any enactment, regulation enacted under it, or agreement or contract that is in force as a result of any enactment other than the Act of 1972. It was firmly determined that the sixth meeting of the Board of Directors to incorporate the aforesaid Act within their organization. According to Section 4, subsection 3 of the Act, an employee's gratuity cannot be greater than the amount that the central government may from time to time notify. The court relied upon the judgment titled Shri Bhupati Devnath versus the State of Tripura and others. It was further observed that in case where the Payment of Gratuity Act 1972 applies automatically in an establishment, the central government's periodically specified limits must be followed for calculation. The single judge bench of the Calcutta High Court has held that to prove a case under Section 166 of the Motor Vehicle Act, required proof is of preponderance of probabilities. The rash and negligent driving is a sine qua non of cases under Section 166 of the MV Act. The court observed that Section 166 of the MV Act stipulates that the preponderance of the probability must be proven in order to establish a case. Rash or negligent driving is a sine qua non of a case under Section 166 of the MV Act. Both vehicles consolidated with each other to claim that the victim was driving negligently, which caused harm to loss his life, is unreasonable. The Allahabad High Court has held that grounds under Section 11 of the Hindu Marriage Act 1955 are very different from the grounds under Section 12, and thus a petition filed under Section 11 of the Act cannot be judged on ground other than those mentioned in Section 11. The court noted that the family court had considered the provisions of Section 5 and Section 11 of the Act and found that none of the grounds as given in Section 11 of the Act existed in present case, and therefore the petition was dismissed on merits. Further, the court stated that a void marriage is regarded as non-existent or as never having taken place, and such declaration that the marriage is void ab initio can be sought under Section 11 of the Act on the grounds as provided therein, whereas a voidable marriage is regarded as valid and subsisting unless a competent court annuls it, until the decree of nullity is obtained in accordance with the Hindu Marriage Act, and unless the decree is granted, the list remains binding and continues to subsist. Moving on to international news this week. Muslim women hold placards as they stand in protest outside the Palace of Justice on the day the country's federal court delivered a verdict in a constitutional case challenging the legality of some Islamic laws in Kelantan state in Putrajaya, Malaysia. Malaysia's top court declared more than a dozen Islamic laws enacted by the northeastern state of Kelantan as unconstitutional in a decision that could affect the legality of Sharia in other parts of the Muslim majority country. Malaysia has a dual-track legal system with Islamic criminal and family laws applicable to Muslims running alongside civil laws. Islamic laws are enacted by state legislatures while civil laws are passed by the Malaysia's parliament. Donald Trump does not have presidential immunity and can be prosecuted on charges of plotting to overturn the 2020 election. A US court has ruled Mr. Trump has claimed in the landmark legal case that he was immune from criminal charges for acts he has said fall within his duties as president. But a unanimous ruling in Washington, D.C. struck down that claim. It is a setback for Mr. Trump, who has for 4 years cited presidential immunity while battling multiple cases. A South Korean court has acquitted Samsung Electronics chairman Lee Jae-yong of financial crimes involving a contentious merger between Samsung affiliates in 2015 that tightened his grip over South Korea's biggest company. The ruling by the Seoul Central District Court could ease the legal trouble surrounding the Samsung heir less than 2 years after he was pardoned of a separate conviction of bribery in a corruption scandal that toppled a previous South Korean government. The court said that the prosecution failed to sufficiently prove the merger between Samsung C&T and Shield Industries was unlawfully conducted with an aim to strengthen Lee's control over Samsung Electronics. In the end, we have miscellaneous news. The government has accepted the recommendation of a parliamentary committee that the Supreme Court should have regional benches, but has pointed out that the apex court has been consistently rejecting the idea that the issue is of sub judice, the panel said. In its action taken report on its earlier submission on judicial process and their reforms, the Standing Committee on Law and Personnel noted that its recommendation has been accepted by the government. The action taken report of the committee was tabled in the Lok Sabha on Wednesday. In the chapter dealing with recommendations Observations which have been accepted by the government, the panel referred to its earlier recommendation on feasibility of regional benches of the Supreme Court. The committee had earlier noted that the demand for having regional benches of the Supreme Court is about access to justice, which is a fundamental right under the Constitution. There has been a long-standing demand, it noted, for having regional benches of the top court in the country for taking justice to the doorstep of the common citizen. The Delhi High Court has ordered the Public Works Department (PWD) of the Delhi government to promptly prepare an estimate of funds needed for hybrid hearing equipment required in district courts of Delhi. A division bench of Acting Chief Justice Manmohan and Justice Manmeet Preetham Singh Arora has given the department 10 days to submit the report to the Finance Department (GNCTD), who in turn is directed to decide within 4 weeks. The counsel for the High Court laid down the list of equipment required during the hearing, to which the court remarked that the same is bare minimum requirement for the provision of a hybrid hearing and the PWD must provide the same. There is no sense in the Bar Council of India (BCI) having regulatory powers over the entire spectrum of legal education, a parliamentary committee has said, tabling its 142nd report strengthening legal education in view of emerging challenges before the legal profession. In Parliament, the department-related Parliamentary Standing Committee on Personal Public Grievance, Law and Justice said that the PCI has neither power nor expertise to meet the challenge of the ever-changing globalized world. The committee said that the Advocates Act 1961 was enacted with a different limited view of legal education, producing only lawyers for courts, but over the years, legal education has not remained confined to this limited rule. The parliamentary panel recommended that the BCI's power to regulate legal education should be limited to the extent of acquiring basic legal eligibility for practicing at the bar. In its 143rd report titled Review of the Work of Legal Aid under the Legal Services Authorities Act 1987, it has suggested that the Bar Council of India (BCI) should make it mandatory for every lawyer to appear at least in one pro bono work in a year to enable him to secure any relief fund from all India or state bar councils. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.